I'm here to talk today about Stop the Beach Renourishment versus State of Florida. Let me set the stage for this case. We have beachfront owners in Destin, Florida, up in the Panhandle, that own land right along the beach. And they say that their land is not eroding, their land is not subject to erosion like many areas of the state. And in fact, after a hurricane, yeah, they do lose some of their sand, but it comes back. And so when the local government and the state government came to them with a beach renourishment program, meaning they would put new sand onto the beach, they didn't want any part of that. They didn't need the new sand, and they didn't want the new sand. Why didn't they want the new sand? They didn't want the new sand because that would mean that the public would have a new beach right in front of their existing beach. Right now, they own property to the mean high tide line. That means in the summertime, when it's good beach weather, the public can cross along the beach and can use the amount of sand that's exposed between the high tide line and the low tide line. And there is enough room for some public, but not a huge public beach. But the state of Florida had a renourishment program where they would put 75 feet of new sand in front of their property, making it available for all manner of public in the public beach and all that goes with that, the noise, the pollution, the problems they had that they didn't want. So they argued that they had a right under Florida law to be able to touch the water directly with their property. And indeed, under the common law of Florida, there was a tradition that beachfront property owners had the right to have their water touch the water at least at high tide and the average high tide line. When this got to the Florida Supreme Court, a sharply divided court said, no, you don't have any right to touch the water. You have a right to access the water, but essentially what you thought you had in beachfront property now is only beach view property, worth, according to the landowners, quite a bit less. Now, there is a strong dissent in Florida that said, hey, Florida majority, you have completely changed and altered the law of Florida right now, and you have taken away these individuals' property rights. And so the landowners went to the U.S. Supreme Court arguing a rather unique theory, arguing that the state Supreme Court in Florida took their property, took the right to access and touch the beach directly. The United States Supreme Court surprisingly took the case because it had never before taken a case where there's been an allegation of a judicial taking, where the allegation that the court itself, rather than a government agency or a governor or a executive agency, has taken property. So the U.S. Supreme Court took this case, and the decision that they just issued, 8 members of the court said, no, this is not a taking of the property because the placement of the sand by the state was a very sudden and rapid putting of sand on the beach. And when you have a sudden deposition of sand, then that new sand does not change the property boundary, and indeed the landowners lost nothing. For the landowners, that's a significant loss. They had hoped to maintain the status quo. They did not get to do that. But what did change is that 4 members of the court said that if the Florida Supreme Court had taken the property, that indeed would be a judicial taking. 2 members of the court, on the other hand, said no, we don't think it was a taking, but we think it might be a violation of another section of the Constitution, a due process, if a court were to take the property. And 2 other members of the court said it's too soon to reach that. So what do we have here? We have 8 members of the court deciding it was not a taking. Justice Stevens, who owns beachfront property in Florida, did not participate in the case. We had 4 members led by Justice Scalia saying that if a court had changed the property boundary, it would be a judicial taking. 4 members of the court saying we're not going to reach that question, but of those, 2 saying it might be a violation of a different section of the Constitution. This issue is going to come back to the U.S. Supreme Court, I think, in very short order. For example, right now there's a case in Hawaii where the state Supreme Court turned down a case where landowners had argued that the state of Hawaii had changed the rules by saying that slowly deposited property through accretion does not change the boundary line there. So a different set of facts, one that the U.S. Supreme Court may take. But what we know at the end of this case is that the doctrine that a court, through ruling and destroying people's property rights that way may someday be liable for a judicial taking. Stay tuned.
For more PLF videos, visit our YouTube channel.